welcome to the DMH Stallard Employment Law podcast. We're going to be talking today about whistleblowing, recent developments in case law, and what the future holds in this area in light of the legislative changes that are going to be coming up as a result of the Employment Rights Bill. We've had a lot in the news over the last year or so around significant changes to employment legislation and what's coming under this new Labour government. But it tends to have been, I think, on things like day one rights and status of gig economy workers that are the areas that have dominated the headlines. So it's a chance today for us to talk and look at changes coming in respect of an area that gets really a little bit less attention around whistleblowing. And that might in part be because the changes being proposed actually on their face look quite simple and low in impact. But on closer inspection, actually, they've got the potential to quite fundamentally shift the nature and frequency of whistleblowing disclosures that you might be seeing in the workplace and dealing with. On the one hand, there's going to be a broader scope to the subject matter on which you could make a protected disclosure. And on the other, a potential reduction in the sort of need to become a whistleblower once these day one rights come in. So there's quite a lot going on and sitting underneath it. I'm going to be hosting the session today. I'm Adam Williams in the Employment Department at DMH Stallard. With me to discuss recent developments and the future of whistleblowing in the workplace are Rebecca Thornley-Gibson, partner in the employment team here with over 30 years experience seeing the good, the bad, and as she puts it, downright ugly in employee relations. Rebecca's got significant experience working with large employers dealing with complex and contentious issues like protected and qualifying disclosures and harassment allegations, which for reasons we'll come on to will be looming quite large in this discussion. Hello, welcome, Rebecca.
Hi, Adam. Good to be here.
Good. And we've also got Holly Ryan, partner in the Employment Department here at DMH Stallard. And Holly helps employers navigate thorny employment disputes and defend tribunal claims, including those involving protected disclosures and, as we'll come on to, allegations of sexual harassment. So, talking points then. I think I'd like us to pick up on recent sort of binding case law developments a little later on in the session, if that's okay with you both, and start with these legislative changes and some areas that are already in the legislation, but which I guess in theory might come more to the fore as a result of what we're seeing as changes in it. So if I kick off with you, Holly, one of the key changes in the legislative framework is the addition of sexual harassment as a relevant matter that can form the subject of a protected disclosure. Can we just start by exploring that and what it might mean in practical terms? Do you see it as a step change in how employees might raise issues, or is it essentially kind of an irrelevance and unnecessary because of, for example, victimization provisions under the Equality Act, which you'd say look probably on their face quite similar?
Yes, absolutely. So I think raising concerns or a grievance about sexual harassment would almost certainly constitute a protected act for victimisation purposes under the Equality Act. But savvy and perhaps well-advised employees are likely to want to raise the matter as a whistleblowing complaint as well for several reasons. Firstly, it will require an additional layer of investigation on the part of the employer and oversight of that in process. Secondly, if an employee lodges a claim in the employment tribunal, that will give them potentially an alternative means of protection, as a different statutory test would apply in that particular instance. So if for any reason the victimisation claim fails, there's a possibility that they may be protected under whistleblowing legislation and that claim would still survive, which is quite helpful and gives them an additional comfort there. Thirdly, an employee can consent to the tribunal passing details of the case to the relevant regulator, which may result in the regulator undertaking investigation into the respondent's actions and the substance of those allegations, which would be separate to the tribunal proceedings, which certainly could add an additional layer of oversight, but also could potentially be used as a negotiating tool. And then finally, and probably more crucially, although I'll go on to explain why it may not be as often used as we would anticipate. But once sexual harassment can be raised as a whistleblowing complaint in the new world, there will be an ability for employees to seek interim relief from dismissal, which is where an individual can seek an order from the tribunal that the employee's employment will continue pending final determination of the case. So
that's not available for victimisation, is it?
It's not. No, it isn't. Yeah. And it's not a remedy that's available under the Equality Act. But the downside to this is, and I think it would be a case of when an employee is either in the midst of raising a grievance and is already seeking legal advice, they have to make that claim relatively promptly. It's within 7 days of dismissal in order to apply for interim relief. But it does solve that issue of people having the means to pursue a tribunal claim, because then they could still be receiving their salary. But the reality is, I think it remains to be seen how many employees would actually make that application, given that it has to be made so promptly. Well, I mean, 7 days is no time at all, really.
No, I don't know how many of you listening have actually had to face one of those interim relief applications, but us as practitioners, I mean, they are very few and far between. Rebecca, if you could talk to that a little bit about this remedy. I mean, it clearly on its face is extremely powerful. And I guess the point is that once sexual harassment becomes a qualifying disclosure, it opens it up as something that can be deployed in a much broader range of contexts. But could you just talk us through how it works and perhaps why it's not very well used?
Yes, Adam, absolutely. I mean, in 30 years, I've only been on the receiving end of 2 interim relief applications, which shows it's relatively rare as a remedy. Whether it increases because of the addition of sexual harassment as a protected disclosure remains to be seen. But a lot of employees will be perhaps not aware, particularly they're a litigant in person, of the fact that interim relief is available. If they are represented, they may not have the funds to make an interim relief application.
Yeah.
But the threat of an interim relief application is going to be fairly good leverage for negotiations, albeit, as Holly said, you have the 7-day time limit. So an employer may just decide to kick the can down the road on the negotiations and test whether you're actually going to make that interim relief application. But it has been available in whistleblowing situations for quite a while and isn't really used that much.
It's obviously the 2 examples you'd had, were they whistleblowing or were they trade union? Because that's the other area where
union. Yeah, they were trade union dismissals. So they obviously then had the backing of the trade union law funds themselves and the knowledge of the trade union officials of that particular remedy. But as a remedy, if it's successful, wow, it's incredibly powerful. The ET are pretty much saying if they award the interim relief, that the substantive claim has got pretty good chances of success at the final hearing. So that is going to be a big, a really sort of big incentive for the employer to settle early.
Really good point. Really good point. Yeah, because they're getting all sorts of indications that this is not going to go away, not going to be easy, and you might fall over at the end of it. Very, very helpful. So taking that into account, we've clearly established there's potentially very good reasons why disclosure based on belief that sexual harassment's occurred will be something workers will want to raise, certainly as if they're aware of it. The interim relief might be a bit of a barrier around knowledge and education on that, and whether there's a body or party that can support and get them to do it quickly enough. But an important point here, Holly, is that similar to victimisation and protected act, which is a distinct statutory test, as you said, the worker doesn't have to be the victim of the sexual harassment to make a protected disclosure and gain protection. Do you mind just recapping, Holly, what circumstances what the circumstances are when a disclosure of a whistleblowing concern is not qualifying, because it certainly isn't that, is it? It isn't that, oh, well, it wasn't you who was harassed, so you can't raise it. What are the things that might disentitle you to protection in a disclosure?
Yeah, no, it's a good question. And I suppose a part of that is probably just kind of giving a brief overview of what constitutes a qualifying or protected disclosure. I suppose I'm sure many of our listeners will know what that is, but by way of brief reminder, so a worker or an employee makes a protected disclosure if they make a disclosure of information which tends to show that past, future, or present wrongdoing, and there are 6 grounds currently at least on which they can do that, which includes kind of breach of a legal obligation, criminal offence, etc. I won't go through all of them. I'm sure most of our listeners will be familiar with them, and that worker has to show that they have a reasonable belief that the information tends to show one of those particular failures, and a reasonable belief that the disclosure is in the public interest. And this is where there's been a lot of case law on this public interest test. The public interest element was added following the Parkinson-Sodexo EAT case, where it was an appeals tribunal decision which confirmed that a breach of an individual's employment contract could constitute a qualifying disclosure, effectively. And so what happened is the public interest test element was added to avoid employees blowing the whistle on private workplace disputes. Although there has been a lot of case law on this particular point, and it can be reasonable in some cases for a worker to show that a breach of their own contract is in the public interest to satisfy that public interest test. The leading case on that is the Court of Appeal decision in Chesterton and Nur Mohammed, and that case concerned disclosures by a senior manager at Chesterton's about manipulation of a company's accounts, which affected that particular individual, but also a larger group of senior managers. I think it was over 100. And in that particular case, although it related to the individual's terms and conditions of employment, the Court of Appeal found that disclosure was a qualifying disclosure, even though it related to his terms, because it also related to or affected several other hundreds of managers as well. So there's been a lot of case law on those particular points. Effectively, what a tribunal needs to do is, when they're considering whether the disclosure was in the public interest, they will look at whether the individual reasonably believed the disclosure was in the public interest, and whether that belief was objectively justified. And then the tribunal will go on to look at the number of individuals that are affected, the nature of the wrongdoing, and the identity of the wrongdoer. And there have been various decisions that have fallen on either end of that spectrum. One case fell down, I think Parsons and Airplus International Limited, was when one individual raised concerns just about her own contract, and that didn't satisfy that public interest test.
So that's interesting, because that we talked about, you don't need to be the victim yourself, but actually, if you are raising the concern that you believe you have been sexually harassed, I suspect we all agree that probably only in that scenario could you even really say there's no public interest. Well, that would be my view, that otherwise I think it's extremely difficult to try and, as an employer, run the public interest. And even if it is only about you, what do we think the position is around public interest? My sense is it's not going to be a very easy way for an employer to demonstrate that it's not qualifying or protected disclosure.
No, exactly. I think the addition of sexual harassment removes that barrier in terms of the worker having to prove that disclosure falls under those existing types of wrongdoing, which was the previous issue. But the public interest test will probably be satisfied in most cases, because most employers have a public face to them. And also, I suppose you're getting increased pressure from regulators as well to treat, such as the FCA and the SRA, to name a couple, to treat allegations of harassment quite seriously.
Yes,
and support them as professional disciplinary issues.
Yeah, and the employer's duty now to take reasonable steps. So there's lots of different ways in which the individual could say, even if it's just about me or someone close to me, there are all these other reasons why it's in the public interest to know whether this stuff's happening and whether an employer is doing what they need to do.
Potentially, yes.
Yeah, okay. So we know what the new position will be under the legislation and key changes. Rebecca, there's been some quite seismic shifts in this area in EU legislation, though, as well, at European level. And those changes won't have direct effect in the UK because of our departure from the EU. If people are listening, they'd probably quite like to hear what those key differences are, and I guess whether we dodged a bullet there from an employer perspective in not being subject to this new revised position under EU directive.
Yeah, I suppose it depends on the dodging the bullet, whether you're the employer or the employee. But
Indeed.
Yeah, absolutely, the EU directive provides that greater protection for whistleblowers, and it looked until last month that the Employment Rights Bill was also going to add to the protections for whistleblowers as well. But the various strengthening of those protections that the House of Lords had proposed were then rejected by the government, and those included the duty of an employer to investigate whistleblowing complaints, which the EU directive requires, and also the requirement to have specific reporting channels, which again the EU directive requires. So both of those things looked as though they were going to be introduced into UK legislation, but now won't, which perhaps runs contrary to the Employment Rights Bill generally, which seems to enhance employee rights. But on certain of the ancillary whistleblowing protections, the Employment Rights Bill has watered down those rights. But with the EU directive, what has happened here is that obviously member states are required to adopt it and have done since December 2023. But the question is always, what about employers that are which are part of a group who have entities in the EU? So, for example, you are a global employer with multiple jurisdictions, including those in EU member states, and you may want to use a centralized function for reporting of whistleblowing. What the EU has said is, no, you actually have to have a separate reporting function for each legal entity. It's not enough to have a global central reporting function. So that can be quite cumbersome. The pragmatic response to that has been that the EU Commission has said, look, have your centralized group function as long as you also have the ability for individuals to then choose a separate legal entity reporting function. So you have to set up that separate legal entity function, but you might encourage, as that global employer, for employees to use the centralized group function. But it's not ideal at all. And the other aspects that are worth pointing out with the EU directive, which are providing more enhanced protection, is the wider category of individuals that whistleblowing applies to. So it will apply not just to workers and employees, but self-employed, shareholders, volunteers, and interestingly, those who assist whistleblowers, so facilitators, who might be assisting the whistleblower, and also colleagues and family who may suffer retaliation as part of their association with the whistleblower as well. So a really wide group of individuals that are captured and protected under EU whistleblowing legislation now.
Yeah, and if you've got operations that are spanning UK and Europe, then there's actually you haven't completely dodged a bullet. There's some quite careful considerations to think about there in terms of how and when that broader and more onerous scope of protection and duties might arise, and how you manage it on those areas.
Absolutely, and I think it's also worth pointing out that it's the employees or the individuals within the legal entity. So the legal entity may be an EU member state legal entity, but the individuals in that legal entity may actually be carrying out some of their work in the UK, for example. So you've got a mix of overseas legal entity employees or workers who are then mixed into your geographic location in the UK.
Yeah, careful thought required.
Absolutely, yes. Complexities definitely exist. Yes.
Thank you. Right, but before we opine on what all these changes, we're going to focus on the UK ones, but we need to keep in mind the possible impact more broadly of the EU changes for those who've got operations across Europe or into Europe. Before we do that, and talk about what the nature and frequency of whistleblowing disclosures might become in the workplace, can I just get a quick take from each of you on what you think is a helpful kind of recent case in the UK on whistleblowing, to give, I'm sure listeners would like to get a sense of the way that the tribunals are dealing with the issue, even under the current framework. Some of these decisions will still be relevant as we move into the new world. So I think that'd be quite good. Holly, should we go with you first? Which one would you like to share?
Yeah, I was going to touch on it's a recent EAT decision, Nickel and World Trade Travel and Tourism Council, which came out last year. And in that particular case, Mr. Nickel raised concerns to an HR consultant about his CEO's managerial style. And the CEO was informed that concerns had been raised, but she wasn't told about the substance of those concerns. And then shortly after this, Mr. Nickel was dismissed, I believe for redundancy reasons. And Mr. Nickel claimed automatic unfair dismissal as a result of raising a whistleblowing complaint under Section 103A of the ERA, which
and that's actually a very common way in which these sorts of claims would be presented, wouldn't they?
Absolutely, by an employee, yes.
Given by the employer. Employee says, no, but for the disclosure, none of this would be happening
dismissed.
To me.
Exactly that.
Yeah.
But the EAT in this particular case found that the decision maker, so the individual that dismissed him, which was the CEO, had not been aware of the substance, the protected disclosure that he had made. And I think actually found that the CEO and actually the person to whom he raised the complaint didn't consider the individual, Mr. Nickel, to be a whistleblower in any event, and his claim failed. And the EAT upheld the tribunal's decision. They felt that whilst the disclosure had been made, the decision maker must at least have some knowledge about the substance of the disclosure to be liable for the unfair dismissal claim under Section 103A. And in this particular case, the individual wasn't. Only an awareness that a concern had been raised is not sufficient. The EAT felt in this particular case to establish causation, so to make that causal link between the individual raising that whistleblowing complaint and ultimately their dismissal. So from an employee's perspective, it's a slightly more concerning decision. So it looks like, I think, much will probably turn on what is meant by sufficient detail of the protected disclosure, and then obviously making that causal link much clearer. And obviously he couldn't do that in this particular case.
No, and I mean, yeah, an employer-friendly decision. Bit harsh. I don't know what you think,
felt
Rebecca,
it was a bit harsh.
The whole, but now remembering the origins of whistleblowing protection, because I think it was UK rather than EU derived. This was about being able to raise concerns without fear of reprisals. The idea that unless you can be sure that the people who are going to retaliate just because they feel you've said something negative about them, unless you can be sure they're going to know what you said, you won't be protected. Does seem harsh to me, because really it only takes a decision maker to feel, I know you've said something about me. And it doesn't really matter what it is. I'm just going to, so I don't know, Rebecca, what do you think? I'm usually on the side of the employers, the angels, here, but it seems a bit harsh to me.
Well, it does, on the basis that the knowledge of the decision maker, they were effectively almost an innocent decision maker in respect of the knowledge of the substance of the whistleblowing complaints.
Yeah.
But I think we've had
quite sure you've got protection unless you can be sure that the individual who knows you've said something about them and might want to dismiss you for it, you can show they actually knew the detail of what you'd said, which is somewhat, unless you tell it to them direct, is out of your control to a degree. I guess maybe that's the learning point. If you're an employee or worker, it might make things worse, actually. But if you want to ensure you've got protection, if this case is good law, you've got to kind of lay on the detail to the individual that you think might hold the decision-making power.
Yeah, I think we've got more cases on that coming up. I think Henderson, which is a very recent judgment, but which will be remitted to the tribunal for some of its appeal aspects. I think we will see sort of more of this innocent sort of dismissing manager thought processes in Henderson as well.
Got you. But you've given us a bit of a teaser there to a future.
No, I'm going
Yes.
to
Do you want to touch on that?
case
Or have you got another?
Chase and Northern Housing, which is still very, very recent. So it was just a few weeks ago. But in that case, it concerned whether whistleblowing disclosures that were made to an external investigator could be protected under the legislation. And the tribunal, the Employment Appeal Tribunal, looked at whether they were capable of protection. So a situation where quite regularly an external investigator will be asked by the employer to investigate complaints. So that internal investigator held the meetings with the employee. The employee then raised additional complaints, additional disclosures effectively to that external investigator. And the employer said, well, we didn't authorize those complaints to be made. We didn't have a policy that authorized those complaints to be made to an external investigator. And on that basis, those complaints have lost their protection. And the Employment Appeal Tribunal said, no, we're not going to say that, the authorization must expressly, sort of state that it has to be made to an external investigator. It's effectively implicit that an external investigator is going to consider previous complaints, probably hear more detail about those complaints, and possibly hear new complaints. And as far as the employer is concerned, it's pretty obvious that that external investigator would therefore be implicitly authorized as somebody to whom the protected disclosures could be made. So I think what the practical impact of that is that employers need to know that effectively the terms of reference of the external investigators are in some way expanded to be the recipient of additional disclosures. Yeah. And if additional disclosures are made, then the external investigator also needs to relay those back to the relevant individual at the employer organisation.
Mm. You can see why ultimately that decision was made, can't you? The purposive approach, because this is about encouraging legitimate, genuine beliefs in malpractice, not finding a way to go, well, and you need to jump through all of these hoops for it to be authorised and for us to do it, and it just goes against the whole purpose. Really
Definitely. I mean, I'm really surprised, hot off the press, and surprised that the employer did appeal that. It was probably a common sense judgment by the EAT.
Yeah. Right, wrapping up time. Let's take stock on what we think the practical implications will be for employers, these upcoming legislative changes, particularly in terms of number and nature rather and frequency of protected disclosures. My own view is that there might be a bit of a reduction in claims because all those who would have previously needed 2 years service to challenge a dismissal won't need it anymore, and will be necessarily needing to identify unlawful or automatically unfair behaviour once the day one rights come in. But there's going to be complexity around day one rights and the sort of probationary periods through which employers can somewhat avoid liability, and we touched on differences between victimisation and whistleblowing, but there's also difference between unfair dismissal and whistleblowing in terms of capped compensation as well, etc. So I personally think there might be a modest downward trend, but actually sexual harassment being added as one of the new subject matter, I reckon overall we're going to see an increase. But I want both of your takes on it.
I think Adam, I think we'll see an initial increase because the reason for that is the awareness of rights.
Yeah.
So whenever you have something that is in the press, which undoubtedly the sexual harassment as a protected disclosure will be, then I think that you're probably going to have a spike. Greater legislative protections, will be there. I think we are still seeing a lot of complexity over the whistleblowing cases that are coming out. You'd think after 25 years of the whistleblowing legislation being in force, we would have got things right, but there's still a lot of complexity. And where there's complexity, employers run scared. And where employers run scared, employees think, oh, this would be quite a good claim because it's a bit more complicated. So I think there will be an initial increase in whistleblowing claims.
All right.
Yeah.
Price
I agree with
right,
Rebecca.
Holly.
I think
Higher
we'll
or
see an
lower?
initial spike. And I think largely because I know employment lawyers, we get very excited about all the ERB changes, but I think normal people, everyday people are increasingly becoming aware of it just through the media presence. You know, it's widely reported, and also well-advised employees are going to add that for the reasons I mentioned. It gives them this additional protection, the statutory chest. It would be remiss of them not to bring that sort of claim and plead on that basis, I think, if they can. So I think, yes, and initially a spike, whether that will settle where interest is either lost or it's not as, widely reported, perhaps, but I think we'll just have to wait and see.
Thank you both very much. I think the message then for us is clear. It's a very good time to revisit our internal policies and procedures in front of that spike. If it is a spike coming, we all seem to agree that there could be one coming around sexual harassment, grievances, etc., but also whistleblowing policy and procedures. Make sure that we know that our policy, and then actually in terms of real terms, implementation is going to be ready for this and fit for purpose, so that we're well placed to respond if there's an increase in disclosures. We maybe not are predicting lots of interim injunction applications, but also have that in mind as well. We should keep that in mind. And, potential challenges to validity of terminations around that to a degree, but a good time to dust off those policies if they haven't been looked at too recently. Yes, thank you both again. Thanks everyone for listening. A reminder that you can follow our podcast on LinkedIn and get access to it wherever you consume your podcasts. Most channels were available, and there'll be links and information on our website as well that you can access on the subjects we've covered here. And we will be back again soon.